Well, let's move on to disparate impact. Let's say that we have a more traditional interview, Jen and I, and she makes it through the personal interview stage of the process. But when it comes to the performance test, where she has to carry a 150-pound dummy out of a burning building wearing full firefighter gear and all that, hey, it's just a performance test that we give to everybody. She fails it, right? Can't do it. As Mikey said that she couldn't, because look at those arms, right? She didn't do it. Well, in fact, very few women pass my test. Now, is this disparate treatment? No. But Jen might allege disparate impact or adverse impact. Goes by both names. What does that mean, and how is it distinguished from disparate treatment? Yes, Melissa, you want to take a stab at it?
You unintentionally discriminated against her because she can't carry that. The intention was to find somebody that meets these criteria for XYZ reasons that have nothing to do with.
Ignore what I'm writing. Keep going.
Okay, that have nothing. You set these criteria that have nothing to do with discriminating against women, but they unintentionally exclude a certain...
Well, they could either unintentionally or intentionally discriminate, but a whole protected group is screened out by my performance test here. I have what the courts would call a facially neutral policy. On the face of the policy, it looks neutral. On the face of it, it doesn't seem to discriminate. Everybody has to take the test, and 80% of the men pass it and 20% of the women pass it. It seems to discriminate against women. So in operation, it discriminates, but on the face of it, it's simply neutral. Just because a policy has an adverse impact, a disparate impact, does not mean that that policy is illegal. Does not mean that you have violated Title VII. All it means is it has a different impact on one group than it does on the other. There may be legitimate reasons, as some of you are suggesting. Bill?
That's a BOFQ.
No.
You've got, if it's
and neither is it a BFOQ.
The wrong letters, but
that's a different employer defense.
Well, if it's a requirement to take a burning person, like in our fire department, you have to do the same test. Everybody, they tend to be men because no one can.
Well, let me just put this myth to rest. Those of you who read a little bit about the bona fide occupational qualification, that is not the employer defense we're talking about here. That only applies if I say I have a policy that only men can do this job or only women can do this job. It's overt discrimination, and I'll give you all the reasons. The essence of the business is at stake if I hire a male to do this job as a waitress at Hooters. It's a real case. All right? That's where you get into this BFOQ stuff. It's beyond the scope of what we're doing here. But what you read about in the book, that doesn't apply to these adverse impact cases. Because there, it's intentional, it's overt, we admit it's discrimination, and we tell you why. Here, it could be intentional or unintentional, but we just have this facially neutral policy. That Hooters case is not facially neutral. Right? On the face of it, it's discriminatory. Facially neutral policy that in operation discriminates against women. Who has the burden of proof here? Who actually has to prove what here? Well, in this case, we have the employer, you, the manager, having the ultimate burden. Or at least the first burden of proof, I should put it that way. You have to prove that if in fact, I should say it this way, if the employee or the applicant demonstrates some kind of inference of discrimination, looking at your workforce or looking at how this test in operation discriminates against women or men, right, that the percentages are very different, then you have to go back and prove that your test was what they call job-related, and that there's some sort of business necessity for having the test. Yeah, 80% of the men pass and 20% of the women pass. It looks like discrimination, whether it's intentional or unintentional. However, I, as the city attorney, I'm going to have to argue that this is a job-related test, that it is, in fact, a valid indicator of what you need to do on the job. Can you do that in this particular case? Can you as the city make that argument? Pretty easily, in fact? Sure. This is a performance test. If you cannot do this, you cannot be a firefighter. I'm going to be very careful about my language in court, too. All right? It's a performance test. There can be no more valid test than this, other than sending you into an actual burning building. Right? In a real-life situation. So, yeah, it's job-related. Yeah, there's a business necessity. We have to know that people can, in fact, pass this test, can, in fact, perform the job. This is the best way we know how. All right, so the employer has the first burden of proof here. Now, there's another step. The employee can come back and say, yeah, but there's another test. There's another way of meeting your legitimate interests that has less of a disparate impact on women. For example, if you set aside this performance test and I say only people who are 5'10" and a minimum of 180 pounds can be a firefighter. Facially neutral policy, right? On the face of it, there's nothing that looks discriminatory. However, in operation, it's going to screen out a lot more women than it does men. All right? Maybe I can prove job relatedness of that policy, but if I do, the employee can come back, or in this case the applicant, Jen, can come back and say, there is another test that meets your legitimate interest, finding qualified applicants. It's a performance test, and it's going to screen out many fewer women than does your height and weight requirement. The point here, folks, is when you have some kind of employment test, make sure it's valid, make sure it measures what it says it's measuring, make sure it's business related, that there's a business necessity. All right, and make sure that there's no other test that meets those same legitimate interests that has less of a disparate impact.
I read the Hooters case.
You read which case?
The Hooters case.
You
I
did?
read it, yeah. I had a class discussion, and that was a discrimination. It wasn't a job-related test or something like that. Why they won the case?
Who win the case?
Hooters won the case. And it was a bartender who wasn't promoted, and they took instead of girl who needed.
Yeah, they've had several different cases. In one case, the man won the case, and Hooters was found to violate the law. In another case, Hooters won. There have been several cases like that, and they've gone different ways.
Yeah, but there was discrimination. They still won. I think that was in Chicago. They still won the case because they say that he was a guy. He didn't meet the physical, whatever, requirements.
He didn't meet the physical requirements, yeah. Hooters is very blunt about it. Look, we're selling lust, folks. Our primary clientele are men between 21 and 80. They said, that's right in their court documents. I'm not making this up. That's their basic defense. And in fact, the EEOC invested a lot of resources in this case. Hooters came back with a $500,000 campaign, I think, advertising campaign, showing this really hairy guy in a bikini, right, serving drinks. And they put it in, full-page ad in USA Today, the New York Times. This is where your tax dollars are going. The EEOC wants this to happen. Right? EEOC was basically shamed into removing the case from the docket. So there are other ways to battle the government if, in fact, you're not making it in court. You can, anyway. It's an interesting case, and in fact, if you take the employment law class next in the spring, we may get into the more specifics of the Hooters case. You may take it just for that reason. Who knows? A little advertising on my part here. Title VII, as we've said, covers not just race and sex discrimination, but also religious discrimination. And you would have theories of disparate treatment and disparate impact applying there as well. But there is a nuance here that you're going to want to be aware of, especially you folks who might be overt about your religious faith in the workplace. To what extent does an employer have to accommodate your religious requests? For example, if you request to not work on the Sabbath. God said it, I believe it, I'm not going to do it. That sort of thing. I'm not going to work on Sunday. I'll work every other day of the week. I'll work hard. I'll be your best employee. I can't work on Sunday. Sorry. There have been cases, Seventh-day Adventists not working on Saturday, Jews not working on Saturday, other Christians not working on Sunday. How far does an employer have to go? How far do you have to go as a manager to accommodate requests?
As long as the request can be reasonably accommodated.
Without imposing what on the employer? An undue burden, undue hardship. Okay, so we have this continuum. Reasonable accommodation, well, let me put it on this side. Undue hardship on this side, on the left-hand side. And reasonable accommodation on the right-hand side of this continuum. Right? At what point does an accommodation become an undue hardship? Right? Let's say I cannot work on Sunday. Right? I will not work on Sunday. Does the employer have to accommodate my request? Well, it's going to be a function of a lot of things. It's going to be a function of how much it's going to cost the employer to get that work done. How essential is that work? What kind of burden is this on the employer? All right? Courts have drawn a line between on this continuum from undue hardship to reasonable accommodation. And if you want to look up the case, it's TWA versus Hardison is the seminal case in this area, Supreme Court, 1977, where they considered a Seventh-day Adventist request not to work on Saturday. All right? And the accommodations that he requested was, look, you can get somebody else to work on the day. Right? I mean, there's a big airline. I'm a mechanic. You can find somebody else to work, shift it around. Or you can just hire somebody to work temporarily or leave it unfilled or something, but I just can't work on Saturday. Right? I'll work every other day. Well, they had union requirements and they had seniority lists, and it would have undermined those union requirements to switch people around. And so it was a real burden on the employer, or so they claimed. Right? And the Supreme Court sided in this case with TWA, with the employer, and more importantly for our purposes, it drew a line between reasonable accommodation and undue hardship. How far does an employer have to go in order to accommodate your request? It can accommodate this, all the way up to, when does it become an undue hardship? When we have and your book says this, de minimis cost for the employer, a Latin term, meaning essentially minimal. Any kind of minimal cost, they don't have to accommodate your request. Any kind of minimal cost, they don't have to accommodate your request for some sort of accommodation for your religious belief. All right? What are the implications of that? What does that mean? Any kind of minimal cost. So if they have to pay somebody else to do your job for that day, is that more than a minimal cost? Arguably, yes, and it has been found to be more than a minimal cost. If they have to shift around schedules, is that more than a minimal cost? Arguably, yes. If it creates an unfairness, an inequity, and therefore lower morale within your department, is that more than a de minimis cost, more than a minimal cost? Arguably, yes. How much do they have to accommodate under this particular doctrine? How much do you have to accommodate as a manager? How much do they have to accommodate your religious beliefs as your employer? Very little is the point. Only minimally do they have to accommodate you. Okay? Now, we're going to juxtapose that in a minute with the standards of the Americans with Disabilities Act. Just set that aside for a second. That's essentially how accommodation works in religious cases.
I have a question on the level of reasonable accommodation. Mm-hmm. What if you go into an employment situation and you say, as a Christian, I won't work on Sundays, and this manager weighs it and says, well, it will cost me a little, but I'll accommodate you, and even if it costs a little more, I will still accommodate you. Mm-hmm. Past this level. Yeah. Management changes, the new manager comes in and says, no, I will not honor that verbal contract the previous manager made with you.
Yep.
If you don't,
what do you think? I mean, it's going to depend on a lot of things, as we were saying before, but in general, courts tend to be hostile to employee religious belief. In private sector and especially in the public sector. All right, so don't expect too much out of courts. Don't expect anything out of the EEOC in this area. They tend to be very liberal when it comes to accommodating religious belief. All right, let me move quickly through the Age Discrimination and Employment Act, and then spend more time on the Americans with Disabilities Act. And in fact, the ADEA I can do in probably about 30 seconds. Passed in 1967, I think, just a few years after Title VII. Congress basically said, "Oh, we forgot age." And so we're going to stick that in, but not into Title VII, but into its own law. Protects employees who are age 40 and over from job discrimination of any kind. All right? If you require somebody to mandatory retirement, something like that, you're discriminating against people over 40. If you, in a reduction of force, tend to fire people or lay people off who are over 40 disproportionately, you're opening yourself up to a lawsuit here. In this case, it would be a disparate impact lawsuit. We have a policy of severing the highest paid employees. Facially neutral policy. All right? Affects people who are 40 and over a lot more than it affects people who are 39 and under. All right? They turn around and sue you under the ADEA. That's where these cases come up most often. And, in fact, that's where you get these company policies of firing one person here and one person there, one person here and one person there on both sides of the line to protect themselves. Even though from a managerial perspective it doesn't make a lot of sense, but just to insulate themselves from liability under this law. There was a hand up someplace. John.
You know, for companies who are, you know, if they're downsizing or getting rid of the higher paid employees and then they hire the young, you know, MBAs and pay them a lot less, they can get 2 or 3 MBAs for costs.
For some dead wood, right. I know what you're saying, John. Go on.
But to me, that seems just, you know, to a certain extent, if the company is facing financial difficulty. But I mean, would that protect, you know, somebody? You
can make an argument that our criteria for laying off were in fact business related. There was business necessity, they were job related, and so on. But just recognize you're opening yourself up to a lawsuit if you have a higher percentage of folks 40 and over who are fired. That's the way the law works. Now, in some states, and in fact most states, folks who are under 40 are protected. And like in Virginia, you can't discriminate against anyone aged 18 or over. All right, so there's a supplement there. There's still this federal law that you have to pay attention to, but you have to pay attention to the state law too. You can't discriminate against somebody who's 25 because of their age. Yeah, you're too young to work here. You're 25. You figure you're protected. No big deal, right? ADEA only covers people who are 40 and over. You haven't violated federal law, but you violated state law, right? So state law tends to go further than federal law in this case. And you as the employee can always claim the broader rights, whether it's federal law or state law. Whatever gives you more rights, that's what you can rely on as the employee. Okay, that's the ADEA. Let me move then to spend a little more time on the Americans with Disabilities Act, passed in 1990, went into effect 1992, signed by President Bush. It was perhaps the broadest civil rights legislation, certainly for the workplace, but maybe overall, since the 1960s. All right? It says basically that you cannot discriminate against anyone who has a disability. In hiring and firing, in training, scheduling, compensation, all these areas of people management. Okay? Opens up a question, doesn't it? What is a disability? What does it mean to have a disability? Pass out some of these, but throw out some ideas here. Sylvia?
Basically having a handicap that prevents you from performing the job.
Okay, give me an example of a handicap.
A physical handicap. Let's say a person is... thank you.
Physical handicap such as?
He's in a wheelchair.
Okay, in a wheelchair. What else? Blindness? Marcia? I'm sorry, what's that?
Chronic disease.
Some kind of chronic disease, cancer?
HIV.
Okay.
Chronic fatigue.
Excuse me?
Fatigue.
Fatigue?
Chronic fatigue.
Oh, chronic fatigue. You don't mean I'm tired because of my baby.
No.
I'd like to be protected, thank you. I think we need some over here if you'll send them this way. Okay, what else might constitute a disability? Some of the obvious ones. What's that?
An arm, one arm.
Okay, if you're missing a limb. How about things like migraines? How about things like job-related stress? How about things like kleptomania? You laugh. How about mental handicap, emotional problems, those sorts of things? Learning disabilities might qualify as a disability. All right, I mean, you see the can of worms that's been opened by saying people with disabilities, this nebulous term, are protected. Well, so the law and the EEOC has given us some guidance. In this handout here, we see some of the specifics. On the bottom of what's page 28 here for you in this handout, a disabled person is one who, and this is spelled out right in the law, has a physical or mental impairment that substantially limits one or more major life activities, or has a record of such an impairment, or, up on the top of 29, is regarded by the employer or potential employer as having such an impairment. Well, that's a little more helpful. We're a little closer, but we're not quite there. So the EEOC has unpacked these terms further and said, all right, what do we mean by physical impairment? Physiological conditions or disorders like problems with speech, sight, hearing, walking, and diseases like epilepsy, cerebral palsy, MS, diabetes, cancer, heart condition, obesity, tuberculosis, and HIV/AIDS. There are some things there that seem obvious, right? Problems with speech or hearing or walking and so on, and some that might be on the borderline. Obesity? HIV? Is it a disability? There's no question about whether it's a disability under the law. It is. It's right here in the law. All right? Obesity, that doesn't mean you're 10 pounds overweight. That's not what they're talking about here. This is a medical definition of, don't quote me on this, even though we're on mic. It's something like 100 pounds overweight for your size, or twice the normal weight for your size, or something like that. But there is a line drawn between overweight and obese. So that's what they're referring to here. But it spells out what we mean by physical impairment. However, it says that physical problems that are neither permanent nor chronic, like broken bones, sprains, and the flu, will not qualify. You're not disabled just because you have the flu. You're not disabled because you have a broken leg. All right, you're not protected by the law. Melissa?
So I'm asthmatic, so technically I'm disabled.
Asthmatics would most likely qualify here. I don't see it specifically in there, but...
It's chronic or not chronic. Chronic asthma.
But I mean, that's very interesting that they would make that so broad.
Mm-hmm. Yeah, it is a pretty broad law. Those of you who administer under this law, you know. If you're in any kind of human resource capacity or just you manage a lot of people, you're going to run up against this. Mental impairment. Right? Mental or psychological disorders like retardation, dyslexia, learning disabilities, and alcoholism. How about that? So the interviewee brings up the fact that he's going to AA meetings. All right? Or somebody's repeatedly coming to work intoxicated, or intoxicated on the job, or just has some sort of problem with alcohol. Can you take some sort of job action against them? Not immediately. There are certain things that you have to do when you face a disabled employee or applicant. We'll talk about that in a second. But recognize that alcoholism qualifies as a disability under the Americans with Disabilities Act. Okay. However, we see... yes, Blake?
Is that because that they're going by the disease model, that alcoholism is a disease?
They're going by the fact, I think, that alcoholism is something that can be translated genetically or inherited, it can be passed on genetically. All right, so that's where they get that from. That and the fact that a lot of senators happen to drink, maybe. I don't know. However, there are some exceptions. Yes, Maria?
However, the argument against that would be, in the very next sentence, homosexuality, supposedly that could be genetically passed as well.
Okay, well, thank you for that segue. Drug abuse, homosexuality, bisexuality, transvestitism, transsexuality, pedophilia, exhibitionism, voyeurism, gender identity disorders, sexual behavior disorders, pyromania, kleptomania, and compulsive gambling are not considered impairments. You're not disabled if you have any of these under the ADA. Okay? Why? And by the way, these are called the Jesse Helms exceptions in the law, because he was the one who put forward the amendment that, in fact, we don't want to include these. We want to specifically exempt these things from coverage under the law. Why? Why would you have to? I mean, isn't it obvious that exhibitionism, gender identity disorders, pyromania, you like to firebomb your employer's building? No, you're not disabled. I mean, isn't that obvious? Could you imagine some court, say in California, saying, yeah, this is a treatable thing and therefore you're disabled? Right? Sure you could. Yes, Joy.
Because they're saying their choices and not genetically passed on.
Well, that's the implication here. Now, there are arguments on both sides. We're not going to get into those arguments here. Just recognize that in the law, there's a line drawn. And it's obfuscated a bit because you have something like drug abuse. Right? If you're a drug user, you're not protected. You're not disabled. However, if you're in treatment, you're in a 28-day program, then you are disabled. That's been the interpretation of the law. You're protected if you're getting help, because we want to encourage that. So you're protected there, but you're not protected if you're not getting help. All right? This is a very tricky law, and you need to stay up to date on it. The EEOC has a lot of guidelines. You can go to websites. There are a lot of these dedicated to the ADA to stay on top of these sorts of issues. All right? Behooves you to really know what this law is about. All right. So we've had a lot of interesting cases since this law was passed. Questions about whether some chemical imbalance was a disability, caused this guy to continually bring a gun to work. He claimed he had a chemical imbalance that made him bring a gun to work. People have claimed that bad temper is a disability. Poor judgment, because this guy was stalking his girlfriend who worked in another department. Bus driver who had a heart condition, hypertension, and diabetes. He wanted to be protected under the ADA, right, so he can continue to drive a bus. Guy who was stressed out by his boss. He wanted an accommodation of a new boss. Guy who was addicted to internet pornography. Recreational use of the internet at work, wasn't getting a lot of work done. He got fired, and he claimed he was disabled because he was addicted. Teacher who was allergic to perfume. Right? All these things are coming up under the ADA, and the question is, does it qualify as a disability? You have some guidelines here, and perhaps one of the most bizarre ones, I have this from the Chicago Tribune. Cheating is in the genes. Genes with a G here. Will your spouse stray? Will you have an affair? If either of you is a sensation seeker, you might get the urge to cheat. That's what an expert says in the February issue of Shape magazine. This is not the Journal of the American Medical Association. Marvin Zuckerman, a professor of psychology at the University of Delaware, says sensation seekers are those who become bored easily, have especially strong sexual desire and willingness to take great risks and tendency to act impulsively. Now, this is the important part. Zuckerman, who studied personality dynamics for more than 30 years, says it may have a genetic component. Does this have implications for the ADA? We have someone who chronically sexually harasses his subordinates. What could he claim? You laugh. But this is how these cases develop. These are the kinds of things you're going to run into as a manager. I'm going to claim that, hey, look, yeah, I know I'm married, but I've been cheating my whole life, and that's the way it's always been. It was that way before I was married. It's that way after I'm married. Can't help it. I was born this way. It's got a genetic component. All right, so the further science pushes in this direction, the more, quote, disabilities we might have. All right, so just be prepared for the unthinkable as a manager. Bizarre stuff is going to come up, folks. Yes, Colin?
I was just thinking of saying someone works for a a bus company or a trucking company. And in a situation where he's driving and he gets like road rage, he gets real mad, and he cuts off that person and comes out and shot the person. Could that person
claim road rage as a disability? What do you think? Well, first of all, you have this framework to look at, and you get general ideas what the impairments are, but it's not an exhaustive list. Does it substantially limit a major life activity? That's the kind of analysis that would go on. One can certainly make that argument. Regardless of whether you win or lose as an employer, it's going to be expensive, so try to avoid these cases. Now, yes, Christine.
I don't know if you've read about the case where the obese lady at a university said she was discriminated against because the seats were too small. And no, it's serious. And they had to make accommodations for her. Did you read about
I haven't heard about that. I've heard about women who couldn't make it through the aisle in an airplane, saying that they were discriminated against. They couldn't be a flight attendant because of this, and the airline had to accommodate them by making the plane wider or changing the seats or something like that. I mean, folks, this is the nature of employment law. Look. But let's face it, some of this stuff physiological. These are things that folks cannot help a lot of times. So we're trying to be sensitive as much as we can and balance the needs of the employee and the employer here.
This ends Side 1.